Hello, everyone, and welcome back to the judicial process. My name is Dr. Daniel Clay. Today, we are finishing up the lecture that we started last class, specifically looking at pretrial proceedings. So this is pretrial proceedings part 2. In this, we are going to just review the motion to suppress. Then we are going to discuss a couple of other motions, and then we're going to discuss pleas in terms of enforcing pleas and how pleas proceed. So if you recall, a pretrial motion, a motion is basically any written request to the court asking for something. And you can ask for, as we discussed before, literally anything. It's up to the court to decide whether or not they're going to grant it. And obviously you don't want to waste the court's time or make the court angry. So usually motions are going to be fairly commonplace legal issues, right? So there are instances of counsel filing motions to have fruit punch on the table instead of water on the table. Technically, that's a valid motion, right? It's you're just asking something from the court, but it's a really good way to make that court angry because you're wasting their time. That being said, remember we discussed there's really kind of 3 common motions. We discussed in quite some detail the motion to suppress. So if we recall, just as a review, the motion to suppress derives from what's called the exclusionary rule. All right. And the exclusionary rule basically provides that if law enforcement obtains evidence in violation of the 4th Amendment, 5th Amendment, or 6th Amendment, that evidence may not be introduced in trial as evidence to support a defendant's guilt. Now, this occurs during the prosecution's case in chief. So there's quite a bit to break down here. The exclusionary rule really developed in the United States following a case called Weeks versus United States. And it was a very slow developing process and really wasn't until the 1960s in the criminal justice revolution under the Warren Court that we really see a motion to suppress an exclusionary rule really start to become enforced in a meaningful way. Now, that being said, right, motion to suppress, we'll kind of break this down a little bit. Law enforcement can obtain evidence in violation of the Constitution, right? That's kind of the basis of this notion. Now, that being said, a couple of things to keep in mind here are a prosecution cannot bring up suppressed evidence in its case in chief. So that being said, suppressed evidence can be brought up at any other time except the trial, right? So if we are doing a bail hearing and we all agree, we all know, the judge knows, everyone knows that the evidence the law enforcement obtained, right, to make the arrest was obtained illegally, and we all know that it's going to be suppressed. Like, we very rarely do we all agree, but let's say we all agree like this is going to happen. It's going to be suppressed. In this case, at bail hearing, you can still bring in that evidence. All right, so you can say, Your Honor, when they busted down the door, yeah, they didn't have a warrant, but when they busted down the door, they found 5 kilos of cocaine on the coffee room or on the coffee table. To that end, the judge can consider it. And the judge can consider evidence even after they've suppressed it at any stage except the trial itself. But there is a caveat, and we'll get into that. Now, this means that, let's say the person is found guilty at trial, right, which is going to be more difficult when we have evidence that's been suppressed, but let's say the defendant gets found guilty. The judge can consider any illegally obtained evidence, so any evidence that they have suppressed during sentencing, right? So the only time that we're not going to allow evidence to come in, to be used, to be introduced, is at trial, right? We don't want the jury to see it because, again, that would sway them and a violation of the Constitution, and we wouldn't have a meaningful Constitution. So we hide it from the jury. Now, that being said, most defense, it's doing criminal defense, it's almost malpractice not to file a motion to suppress some type of evidence, right? And the reasoning behind this is because, especially with simple possession charges, so if we're thinking something like the possession of, let's say, cocaine, right? But simple possession charge of cocaine, and police found this cocaine illegally, right? They just randomly kicked down a door and found some cocaine in this guy's house. They didn't have a warrant, any kind of suspicion, anything along those lines. Well, it's going to be really hard to prove to a jury that somebody was in possession of cocaine if you cannot mention the cocaine, if you cannot bring in evidence of the cocaine, if you cannot discuss the cocaine, or even hint at there was cocaine. It's really hard to prove possession, right? So in these cases, especially possession cases, suppression is very much a big issue. Now, depending upon the motion, depending upon the ruling of the judge, this can have very, very important consequences, right? So as I said before, it's really hard to prove possession of cocaine without the cocaine. So we can find somebody not guilty who is in fact guilty. It also has consequences in plea bargaining, and we'll discuss plea bargaining in a bit later. But generally speaking, when we talk plea bargaining, you're making a trade-off, right? So the prosecution says, look, I will reduce the charges, or we will agree to a certain sentence, or I'll agree to recommend a certain sentence if you plead guilty, right? So if we have a motion to suppress, that gets ruled in the defendant's favor, but there's still significant evidence that could prove guilt. The prosecutor is probably going to give you a better, because they have a lesser chance of winning, they're probably going to give you a better plea bargain than if you lost, right? So if you lose and now that cocaine can come in or that gun can come in, suddenly that plea bargain, the deals of the plea are going to change, right? It's going to be more prosecution favored, more punishment favored, rather than defense favored. So motion to suppress can have very far-reaching consequences. Now, I said there was a caveat in this idea that something that's been suppressed cannot be introduced at trial. This is true, except if the defense does what we call opens the door, right? So if the defendant references the cocaine, or if the defendant, there's a great way around this, but if the defendant says, yes, I've never possessed cocaine in my life, or I've never used cocaine, or something along those lines, what just happened is that defense has opened the door, because they've made something an issue, a fact that is contested. So the prosecution can get up after the person says, I've never possessed cocaine in my life, and say, well, on the night of December 4th, when they did this illegal search, didn't police officers find a bunch of cocaine on your table? Now, that being said, right, the judge will tell the jury that they can only consider the cocaine that was on the coffee table. They can only consider that as to whether or not the defendant was telling the truth, right? They cannot consider that in terms of evidence of possession of cocaine, which, if you're thinking, like that doesn't make a whole lot of sense. Or you're thinking, wait, the jury's just going to hear cocaine. They're not going to sit there and parse hairs and go, oh, we can't consider it for its evidentiary value, but we can consider it to judge the credibility of the defendant. No, once you open that door, that prosecution can just bolt through it, and they're going to make a big deal about it. Yes, the judge is going to give a limiting instruction, but jurors, they're fairly simple-minded. What they hear is what they're going to go with. So again, it's very important that defense be very aware and very cognizant of anything that has been ruled in their favor, has been suppressed, because if they open the door, the defense can walk through, or excuse me, the prosecution can walk through. So that's just kind of that take. Is defense has to be very careful. This is part of the reason we generally don't want defendants to testify. A lot of times, I mean, most of the times, defendants are guilty, right? So the vast majority plead guilty or are found guilty. But we know starting out that there's probable cause, right? That there's it's probable. It's more likely than not that a crime was committed and this person committed the crime. Now, that being said, a lot of my clients, I mean, most or virtually all of my clients were guilty. To that end, we don't want them to testify because they are going to come across as guilty as sin. Even the best natured ones might say something, they might slip up, and it's going to open the door for the prosecution. And also, if a defendant decides to testify, now they don't have to, they have an absolute right not to testify. But if they decide to testify, they have to sit for cross-examination, right? So that means they have to answer the prosecutor's questions after the defense asks questions. And generally speaking, they cannot assert their Fifth Amendment privilege against self-incrimination at this point, because they've decided to take the stand, they've basically waived it. The idea here is we don't want a defendant taking the stand, saying they're innocent, and then not answering a single question that the prosecutor has because they're saying that it'll incriminate themselves. I mean, even if they did that, a jury is going to see that and go, wait, he said he was innocent, but now he's saying that he's not going to incriminate himself. So that means he's guilty of something. It's always a bad idea, right? And again, the large part of the reason we don't put a defendant on the stand is we don't want them to walk through that door or open the door, and we don't want them to commit perjury or us to subordinate perjury. Now, there's another type of motion that's fairly common. You're going to see this virtually in all criminal cases. And you're going to see this in a different way in civil cases, but you'll have what's called a motion to dismiss, right? A motion to dismiss is fairly simple. It's exactly what it sounds like. It's a motion to dismiss the case, right? Basically saying that the prosecution didn't have probable cause, or based upon the development of facts, something was wrong. There's some kind of issue at play that's not right for the case to go forward. This is very rarely granted, even in the most obvious of cases. So for instance, I had a client who had a girlfriend, and his car was, he had two cars, right? He had his primary vehicle, and then he had a vehicle that was in his name. The title was in his name only. And he let his girlfriend use the car like it was hers, right? So he bought it, but he basically, like, it was her car, he had his car. Now, they get into this fight, like his car's in the shop, so they're riding around together. They're at her parents' house, and the couple gets into a fight, a really, really nasty fight. There's no physical violence, but there is definitely a lot of emotional damage done. And in the moment, the guy decides to, the boyfriend calls off their relationship, says, we're over, we're done, grabs the car keys, runs out or slams the door, walks out to the car, turns on the car, and drives off. Well, the girlfriend and the girlfriend's parents call the police saying that he just stole her vehicle. And the police arrest him, right? And they charge him with the theft of the motor vehicle. Well, the very first thing I did was file a motion to dismiss, right? Because the car was in his name only. Under the law and under just common sense, you cannot steal what belongs to you, right? So he literally took off in his car. She called the police, said that he stole the vehicle, and the prosecution decided they were going to move forward with the case that he stole his own car. And so this just shows how losing these battles are. I make this great argument. I even say, Your Honor, you cannot steal your own vehicle. We have the title, right? And I had a copy of the title, I had a copy of the tags, everything was in his name. I said it was never granted as a gift. Everything was in his name. You cannot steal what is yours. And the judge kind of asked, like, well, isn't this a question of fact better addressed at trial? And I responded to the judge. I said, Judge, yes, it's a question of fact. However, if the fact is so clear that it makes the charge basically unlawful or a form of malicious prosecution, then dismissal is correct. And the judge ultimately ruled against me. The judge, or ruled against my client, I should say. The judge said, no, we're going to have a trial. So the judge refused to dismiss a case where a man was accused of stealing his own car. Yeah, that one has always stuck with me. It's just something that just wasn't right. But I mean, ultimately the defendant ended up accepting a plea deal, because like this thing was going to be hanging over his head for a couple of years. Ultimately accepted a plea deal, and he was not guilty. He stole his own car. I mean, yeah, granted, it wasn't great, it wasn't under good circumstances, but it was his vehicle, right? So that's where we have motions to dismiss. And if you had any other judge or any other setting, and there were some other kind of facts that were problematic, but that was the basis of it. To that end, if you had something along those lines before a different judge, there's a very good chance that it would have been dismissed. The judge would have looked at the title, said, well, you own the car. Like, there's no question about that. So there's no crime that has been committed, right? There's no probable cause, because this just proves there's no probable cause. So that's where you're going to see a motion to dismiss. Another one that you'll see, and again, it's not as often, but especially in like high profile cases or cases that are very severe, so definitely homicides and related cases, you're going to see probably a motion for a change of venue. So the idea behind the motion for a change of venue is you're still on trial, you're still charged with the same charges, but you as the defendant say, yes, under the Constitution, I have the right to be tried in the jurisdiction in the state and the district, the jurisdiction in which I committed the crime or allegedly committed the crime. But you say to the court, yes, that's what the Constitution says, but as a matter of fundamental fairness, I cannot receive a fair trial if we have the trial in this jurisdiction, right? So we need to move the trial. And this might be because the trial is so big that all the jurors know about it, all the press coverage, is about it. So everyone in the town or the county or wherever has already made up their mind as to this person's guilt or innocence. So they're not going to receive a fair trial. People might be able to get to the jurors. So there's all kinds of reasons we do for a change of venue. And we just say, Judge, we're going to have the same trial. You be the same judge. We're just going to have a different location, so that maybe this isn't big breaking news there. The people in this location haven't heard of it, things along those lines. Again, just for fundamental fairness. Now, that being said, there's a really interesting case, and this is a case that I worked on when I worked for the First Circuit for Judge Torea. If you recall the Boston Marathon bombing, the defendant in that case, Tsarnaev, moved because he was having a trial. Was scheduled to have a trial in Boston. So he moved for a change of venue, right? And the rationale was he could not receive a fair trial. And he did this for the first time in a 2-1 decision. My judge said, no, we need to move the trial. The other 2 judges said, no, we keep the trial here. So they kept the trial there. And then jury selection continued. And like they sent out thousands of questionnaires to potential jurors. And jurors would respond with hang him, kill him, blow him up, right? They'd already presumed him guilty and they were irate. I mean, it took, I think one time we were looking at to find a potential impartial juror. We sent out the court sent out 2,000 questionnaires and got like one back that could have been potentially impartial. So what happens is Tsarnaev moves again for a change of venue, and he does this at the district court, and district court denies it. So he files what's called a writ of mandamus with our court. Basically, a writ of mandamus just says you're ordering a person, a public official, to do their job, right? So in this case, you need to order the trial judge to move the trial. And so in this case, we actually took time and had a hearing, and again, a 2-1 decision comes down in which my judge says, no, we need to move the trial out of Boston. Obviously, this person, I mean, it's a Boston Marathon bombing. This person's not going to get a fair trial in Boston. And the other 2 judges said, no, we'll keep it in Boston. And my judge he had a really interesting take on it. And I've actually written some papers based upon our discussions. Was that if you are, I mean, this was a terrorist event, right? And terrorism is not designed just to target the people that it kills, right? Terrorism is designed to affect and terrorize an entire population, right? Or a population center. So in this case, the idea of Boston Marathon bombing, it terrorized and therefore made victims out of everyone in Boston, right? Because it was targeting Boston. So the idea that you could have what I would consider victims being the jurors is fundamentally unfair. And our judge Trade, he made rational compromise. He said, well, if we just move it to basically Springfield, Massachusetts. So still Massachusetts, but just out of Boston. Yeah, everyone's heard about it, but they don't necessarily have that personal connection to it like Bostonians do. Ultimately, right, we lose that argument because the other 2 judges vote against us, and the trial happens, and then Tsarnaev is convicted, and he's given the death penalty. Well, recently, and this developed fairly recently, the First Circuit has overturned his conviction, partially because, overturned his death sentence, partially because of the fundamental unfairness of the trial, specifically the location, right? So basically saying that a change of venue should have been granted. Unfortunately, Judge Torea just passed away just about a couple of months ago. But that was one of his last big pushes, and one of his last decisions was he got to see fairness. Even though Tsarnaev is unquestionably guilty, we still in the United States give a fair trial, and that's what Judge Torea was all about. So he ultimately got to see that before he passed, which was good. But that's change of venue, right? Is just you can't get a fair trial because everybody knows about it, or the press coverage, or whatever. So you want to have it in a different location. Now, one thing to say about motions is generally motions must be decided before the trial, right? And they frequently result in formal hearings. So we'll have a hearing where we might call witnesses. So if I have a suppression hearing, the prosecution is gonna call the police officer. They're gonna question them. Now I'm gonna cross-examine them, all right? And to see if they did in fact violate the Constitution. So we're gonna have almost a mini trial over whatever issue was contested. Now, if the motion is not contested, so for instance, the defendant moves, right? That's what you do in a motion practice is you move. Defendant moves or files a motion for a postponement of the trial to accommodate an expert witness, right? To accommodate their schedule, to get them there, etc. And the government agrees to the motion. Then the court can still deny the motion, but the court's not going to deny the motion. The court's going to say, oh, both parties say that, yep, we want to postpone the trial. Fine by me, we'll postpone the trial. There's no reason to have a formal hearing, right? You just submit the papers to the court, other side agrees, then the court's just going to rule on the papers. Now, I did mention before this concept of plea bargaining. So this definitely occurs before the trial. It can occur during the stages of a trial as well, but generally speaking, it's going to occur before. Now, in plea bargaining, what happens is the defendant and the government engage in coming up with an agreement, right? Basically, under the agreement, the defendant agrees to plead guilty or nolo contendere. In doing so, avoids the time, expense, and uncertainty of a trial in exchange for an agreement by the prosecution or the government, right, for reduced charges, diminished charges, or more certainty in sentencing. Right, so you plead guilty, so we don't have to go to trial, you plead guilty, but we're going to give you something for it. We're going to make, if you went to trial, you would have gotten this, you would have gotten this kind of sentence. We're going to give you a lesser sentence. Just take responsibility and move on, because nobody wants to go to trial. It costs a lot of money, takes a lot of time, and unlike you see on TV, is really boring most of the time. I mean, to the point, like, lawyers sometimes fall asleep during trial when they're representing clients. And the Supreme Court's actually held that as long as the lawyer was awake for the important parts of the trial, falling asleep during trial is completely fine, which is just mind-boggling in and of itself. Now, I digress. That being said, there are three classifications of plea bargains. So there's charge bargaining, there's count bargaining, and there's sentence bargaining. Right, so charge bargaining is basically when the government, when you as the defendant agree to plead guilty or nolo contendere, the government agrees in return to reduce the severity of one or more of the charges. Right, this could include dismissing charges, but that's going to be used under count bargaining. So this would be, think about something like first-degree murder. Well, let's say we're in a death penalty state and you are charged with first-degree murder. So you are looking at the potential of death, right? And if not death, then usually life in prison without the possibility of parole. But oftentimes the prosecution will come to somebody even charged with such a crime, like and again, the more severe the crime, the less likely it is we're going to have good plea or a plea bargain, but it still happens a lot, even in big crimes. So let's say we have the first-degree murder charge. The prosecution is going to come to you as the defendant and say, look, you plead guilty, so we don't have to go to trial. We don't have to, I mean, the trial's going to take days, if not weeks. It's going to cost millions of dollars. Like, it's just going to be a pain. If you plead guilty, then we will say, instead of charging you with first-degree murder, we'll charge you with second-degree murder. All right. Second-degree murder, death penalty is off the table, and the highest sentence you can get, usually, it depends on the state, in second-degree murder is life with the possibility of parole. Right. So the idea is you're saying to this person, we're going to take death off the table. Yeah, you might get off, you might not, but we're going to take death off the table. and you may have a chance to rejoin society on parole, right? So you might get a chance during your lifetime to come back into society. So that's a big one, right? Especially if you are facing the death penalty. That we have people, and we'll talk about enforcing pleas, but there are people who plead guilty. Several people. I mean, a lot of people. We've discussed the number of innocent people in prison. There are innocent people on death row, but there are a lot of innocent people who've pled guilty to second-degree murder when they are completely innocent of anything, right? Because the rationale is, wait, they're charging me. I didn't do anything. Like, but they're charging me, and they have all this evidence, but I didn't do anything. And now my options are hope the jury sees this and realizes I didn't do anything, or I can say that I'm guilty. Yeah, I'm going to go to prison, but I won't die, and I might be able to come out and join society, right? Like that's a big one, right? If we take death penalty off the table, and especially if, and again, if it's the death penalty case, we're probably going to engage in sentence bargaining as opposed to charge bargaining, but you know, it's a possibility, right? They say, well, you know, that's going to be a pretty strong incentive, right, to plead guilty. And we'll talk a little about this when we talk about sentence bargaining as well as count bargaining. There's some problems that kind of come into play. So the second type of bargaining there is count bargaining. Again, in this case, the defendant is agreeing to plead guilty or no lo contendere to a specific charge or charges, and in exchange, the government agrees to dismiss some of the counts contained in the charging document, right? So very rarely is someone just charged with one crime, right? So let's say it's just we pop a small-time drug dealer, right? We're going to charge that drug dealer with possession with intent to distribute drugs. We're going to charge that dealer with possession of the drugs, maybe several counts of possession of the drugs, depending on what we find and the quantities we find, etc. So we might go to the defendant and say, look, if you plead guilty, we'll dismiss the serious charge of intent to distribute, right? You just plead guilty to one count. We'll drop the other counts, just one count of possession of whatever they were dealing. That's a really good bargain, all right? Especially if the person's guilty. I mean, if the person's innocent, it makes things more difficult. But even if a person's innocent, this idea of, okay, if I get found guilty of possession of cocaine, right? This is my first offense. Chances are I'm going to get probation. But if I'm found guilty of dealing cocaine, I might as well just get ready for prison, because you're going to go away for some time, right? So one lets you literally just walk out the door, right? Of you plead guilty, you move to sentencing. At sentencing, the judge says, first offense, okay, all right, just possession, and they let it go. Now, defense is going to consider, or the judge will consider what the original charges were, and they're not supposed to, but they will, what the original charges were and things like that. But generally speaking, it's a lot better for you and your record. Think about when you get out, if you go to prison. People are much more likely to hire somebody who got found guilty of possession of marijuana or possession of cocaine, as opposed to somebody who was dealing it, right? You're still not going to have a great chance of getting a job, period, but you're going to have a better chance if it's something very minor compared to something like distribution. Right? And then the third is sentence bargaining. Now, there's really kind of two types of sentence bargaining. Again, in this case, the defendant agrees to plead guilty or nolo contendere to an offense. And it's going to be maybe we have charge bargaining, maybe we have count bargaining, maybe we have sentence bargaining. We can have all three, right? Or we can have two of the three, or we can have one of the three. It just depends on how the person was charged and what the best deal we're making is. Now, in sentence bargaining, you plead guilty and the government agrees to a particular sentence, right? Or to make a favorable sentencing recommendation to the judge. Now, this is where things get interesting, especially at the federal level. So in sentence bargaining, you say to the prosecution and the defendant jointly agree that this person will plead guilty and they will receive probation, right? And so you both agree to that, both sides agree, and you go to the judge. You say, Judge, we've agreed that he'll plead guilty, but he will receive a sentence of probation. Now, judges aren't going to be too happy. They're not usually too happy with these types of pleas where there's a definite sentence, because that's their job, right? And basically you're taking away their job. But most of the time, if it's a fair sentence, they're going to agree to it, right? Like, why, if both parties are cool with it, why do I care? Now, sometimes the judge is not going to be okay with it. Judge is going to say, are you kidding me? Probation? This carries a 5-year mandatory minimum at best, right? And the judge just loses their mind. The judge can reject the guilty plea, right? The judge can say, you know what? No, I'm not going to give probation. Well, in that case, the defendant is allowed to withdraw their guilty plea, right? Because the only reason they pled guilty was because the government agreed to give them a recommendation or give them a specific sentence. So they can withdraw their guilty plea and plead not, and go back to not guilty and go to trial, or they might just see what the judge is thinking and plead to that, right? So there's a lot that can happen, but generally speaking, you get the chance to withdraw if you've agreed to a sentence and you don't get that sentence. That being said, what happens more frequently, because that's fairly rare, what happens more frequently with sentencing bargaining is the prosecution agrees that, if this person pleads guilty, maybe we engage in charge bargaining, count bargaining, and sentence bargaining, or just sentence bargaining. But if this person pleads guilty, the government will agree to make a favorable sentencing recommendation to the judge. Right? So if we both think like, okay, 5 years in prison, that's what we both think is fair. This sentence carries up to 15 years. This charge carries up to 15 years in prison. But we both agree that 5 years is what's fair. But we're not going to make this a basically deal or no deal agreement, right? Of well, if the judge says this, no, what's going to happen is we'll more frequently go to the judge and you'll have a sentencing hearing, and the defendant, the prosecution will be asked, what sentence do you recommend? And in this case, all they have to do for the plea bargain is say, well, we recommend what they agreed to, right? The 5 years. We recommend 5 years of incarceration. Now, the defendant generally has to go along with it and also say, they'll ask the defendants, what do you think is a fair sentence? They'll say 5 years. Usually if the prosecution whatever the prosecution recommends is usually what the sentencing judge will go along with if both sides say the exact same year, right? Exact same sentence. The judge will generally go along with it, but they feel better because they get to make the decision. But let's say the judge says, okay, I've heard the prosecution say 5 years. I've heard the defense say 5 years. I think this is more severe. I'm going to sentence this person to 10 years. You cannot withdraw your plea, right? That's the weird thing about this one, sentencing bargaining, is you cannot withdraw your plea. I mean, there are instances where you can, but you can't. It's not like, oh, the judge didn't agree to the 5 years, so I'm back to going to trial. The plea is off. No, you've pled guilty, and the prosecution did exactly what they promised. They made a recommendation that was favorable to you. The judge didn't agree. oh, well, right? Like, you pled guilty, like they have done their job. They did not guarantee you a sentence of 5 years. They said they would agree to recommend a sentence of 5 years. Ultimately, it's up to the judge. So in that case, sentencing bargaining happens a lot more frequently than you would think. Yeah, there is some element of risk, right? Because the judge could just be really angry that day. No, we're not doing that. But it's usually happens more often than not. We're talking, usually we're engaging in sentencing bargaining. Usually we're engaged in the type of sentencing bargaining where we agree to make a favorable recommendation. And most of the time, the judge is going to go along with whatever the parties have both agreed to or what the prosecution has said, whatever. If the parties both say 5 years, or the parties both say minimum, or they say probation, or they say 10 years, whatever they say, if both parties say it, the judge is usually going to go along with it, unless there's some really, really good reason not to. Now, the judge doesn't have to give a reason not to, but the judge does have to give a reason as to why they gave the sentence that they gave. So again, this, based upon bargaining, based upon the outcomes of bargaining, based upon the outcomes of even pretrial motions, right? It really depends upon how the pretrial matters are handled as to what the sentence and even the guilt or the innocence of the person will ultimately be decided. All right, so the pretrial stage is very, very important. Every charge will go through a pretrial, right? Every single charge. So these stages, right, we're talking motion practice and plea bargaining, are unbelievably important in determining whether or not somebody is found guilty, they are acquitted, and or what their sentence will be. Now, I will say this, just as a note, if you do plead guilty, right? So plea bargaining, you say that you're guilty. In order for a court to accept a guilty plea, the court has to be satisfied that the defendant is entering the plea, quote, voluntarily, knowingly, and understandingly. And as well as absent government coercion so powerful as to, quote, overcome the will of the defendant. Right, so they want to make sure that you're pleading guilty because you are actually guilty, not because there's been coercion, which in plea bargaining, there is coercion, obviously, but not so much that it overcomes your will, right, to understand what you're doing. So you have to do it voluntarily, meaning that you're not being coerced into pleading guilty. You have to do so knowingly and understandingly. So basically, you have to understand what the terms of the plea mean and what it means to plead guilty, what you're giving up, right? You have to be informed of all of that. So in making the decision whether or not somebody is entering a guilty plea that is done so voluntarily, knowingly, and understandingly, the courts will often engage in what's called the plea colloquy. In the colloquy, the court will ask the defendant a series of questions, right? Starting with, what is your name? What is today's date? How far did you go in school? Can you read? Can you write? We'll get, really basic information, which almost kind of seems blatantly offensive, but they're trying to see if, like, this person is being coerced, right? Or if they truly understand. So I watched a sentencing one time where the third question in was, how far did you go in school? And the guy said 3rd grade. And that judge looked right up and looked at the defense attorney and looked at the prosecuting attorney, and just it was dead silence in that court, because this notion of, if you only have a 3rd grade education, can you really appreciate what it means to plead guilty to a crime, right? That you're giving, in this case, it was a felony. So they were giving up the right to a trial. They're giving up the right to, that they have to know that after they get out that, you know, they could be sentenced to prison, but and then regardless, they're going to have a hard time getting a job. They might have a hard time finding housing, all that stuff, and they'll have to do that on their own. They'll lose the right to vote. They'll lose all kinds of rights. Would somebody with a third grade education really understand that and appreciate that? So yeah, it was interesting because that judge just like, it was the deer in the headlights of, wait, what? Because the plea wasn't even that great. The plea deal was not that great, but and I think that's part of the reason the judge was so upset about it, was because the plea deal was really just I mean, it was a joke of a plea deal, and it was quite clear that this defendant was being taken advantage of, and the defense attorney wasn't doing his job. Because after he asked the question, he said, "Can you read English? Can you read English?" And the guy says, "No." "Can you write?" The guy says, I can write my name." And the judge just, before he goes through the rest of the colloquy, because if you actually look, you can find there is the colloquy, there is a manual, and the judge has to read this colloquy line by line, in deciding whether or not a person is voluntarily, knowingly, and understandingly entering into a guilty plea. And it's actually Appendix 5 in the textbook is the plea colloquy. So take a look at it, because the judge can, and in this case did, reject the guilty plea, right? So the court says, no, like this is not okay, right? Like this, he's being taken advantage of. And so the court is really there for fairness, right? We always kind of think of the court as very pro-prosecution. They're supposed to be neutral. They're supposed to be there to protect the rights of the defendant, right? That's kind of the ultimate goal of the courts. And so in this case, that's what the courts are doing, is making sure that this defendant is entering into a normal agreement. Now, usually if somebody has roughly, if somebody's made it to high school, let's say they dropped out at 9th grade or they dropped out at 16, usually the judge is not going to have a problem with the guilty plea, right? Because you can read, you can write, and depending on your age, like if you've lived life long enough that you understand things, like, okay, cool. I mean, if you're just a kid, that's a little different. But usually high school, we're going to be okay with it. If you can read and write at a very basic level, we're going to be okay with it. And you understand, and then we're going to read you your rights and make sure that you understand, that you know that you're giving up the right to a jury trial. You're giving up the right to make that prosecution prove your guilt beyond a reasonable doubt. You are giving up it by making this plea. You could give up certain immigration rights. You can give up the right to vote. You're giving up the right to, you name it. And the judge will go through and line by line has to ask this question to anyone who pleads guilty, whether they're subject to a plea agreement or not. Like I said, in the case that I witnessed, there was a plea agreement and the judge was not happy. Like the prosecution, like the judge almost, I think, jumped off the bench and like almost wanted to strangle the prosecutor. So that being said, if a court rejects the plea agreement, right? So you plead guilty and the court's like, no, this is not okay. We're not going along with this agreement, right? So we're not going along with this, specifically with this sentence, right? If we've agreed to a sentence, and the court says, nope, well, I'm not giving that sentence, the defendant has to be permitted the opportunity to withdraw the guilty plea. And this kind of goes away, and it can't be brought up. This guilty plea or plea negotiations cannot be brought up at trial. A jury cannot hear anything about plea negotiations, right? Or that this person pled guilty and then withdrew their guilty plea, because under those circumstances, no. Now, there are other circumstances when a defendant may withdraw a guilty plea, whether it is whether it's along a plea agreement or without a plea agreement, they're just pleading guilty. So a defendant may withdraw a guilty plea, before the court accepts the plea for any reason or for no reason, right? So you file a paperwork to say that you're wanting to change your plea, and then you back out. You're like, no, I don't want to. The court has not accepted your plea. That's fine. You can change it back not guilty and move on. The court hasn't accepted it yet. So just because you say in papers, yeah, I'm pleading guilty, and then you change your mind, if the court hasn't accepted it, you don't have to give a reason why you're changing your plea. Now things get a lot more tricky the further we go. So let's say that the court accepts your guilty plea. You've pled guilty, but you want to withdraw your guilty plea before the court imposes its sentence, right? Or if the court rejects the plea agreement, the defendant can show, it has to show that the defendant has to show that they do have a reason, right? So again, the court has accepted the guilty plea. They have not imposed the sentence. So there's a little break in between. You can withdraw your guilty plea if you can show, quote, a fair and just reason for requesting the withdrawal, right? So basically it's you have to make a pretty good showing of like new evidence came up, or it would be fundamentally unfair to plead guilty, like this person's obviously innocent, or I was under duress, or I mean there has to be some, you have to give a good reason. You can't just be like, well, I don't like that I'm found guilty, like I don't like it, I don't want to do that anymore. I don't really have a reason besides I don't like it. Like that's not a fair and just reason. You have to give one good reason why you're withdrawing. If you give a good reason, then you withdraw, and then you go to trial just like normal, like nothing happened. If you can't give a good reason, then the court may say, no, you've pled guilty and you don't have a good reason for withdrawing your plea. We're going to sentencing. Right. So, but you can still withdraw. And again, it's not overly hard to come up with a good reason. You can usually find a pretty good reason. But where it becomes virtually impossible is once the court imposes a sentence. Right. So you plead guilty. The court is satisfied that you know what you're doing. It's voluntarily, it's knowingly, it's done understandingly. A defendant may not withdraw the plea once a sentence is issued. Right, so you can't get, so the judge can't say 15 years in prison and you go, ooh, I don't like that, I withdraw my guilty plea, I'm no longer guilty. No, because you accepted the guilty plea, or you pled guilty, like you did so voluntarily, knowingly, and understandingly. So you can't just take your chance and see what the court's going to give you and then withdraw. Right? Instead, a plea may only be set aside on a direct appeal or what's called a collateral attack, where you're basically saying, I'm not guilty, I'm innocent, I'm factually and actually innocent. Even then, it's very hard. Let's keep in mind, we have a lot of people in prison who've pled guilty to crimes that they did not commit. They can't just withdraw their guilty plea. Even if we have like new evidence comes forward and DNA evidence shows that this person did not commit the crime, they still cannot withdraw their guilty plea. Right? They have to engage in a collateral attack where they say, look, I'm not guilty. Even though I pled guilty, I'm actually not guilty. And courts are very skeptical, right? Courts, for whatever reason, still don't understand how the system works, because they'll say, there'll be DNA evidence like this person legitimately, like even the prosecution agrees this person did not commit the crime. Well, the court is the one that gets to decide whether that person gets out of jail or not, or is whatever happens. And courts aren't too keen on letting people who've pled guilty out of prison, even though there's no question that they're innocent, right? And the idea that people have, and it's an unfortunate one that I hear a lot, is why would you plead guilty to something you didn't do? Well, as we've seen in the lecture, and as you've seen in other classes, you would plead guilty to something you didn't do to avoid the consequences of being found guilty of something that you didn't do, right? Of the worst things that could happen. Right? Like, why'd you plead guilty to second-degree murder? Well, I didn't do it, and they were going to and they threatened me with the death penalty. I'm sorry, you threatened me with a death penalty? Like, nope. Like, I'm gonna cave real quick. Again, it's really hard unless you're in that position to understand it. And judges, they're kind of along the same same lines of, why would you plead guilty to something you didn't do? Well, if you guys were gonna find me guilty anyway, and I was facing the death penalty, and this way I didn't have to face the death penalty, right? I could try and prove my innocence because I'd still be alive. So I mean, there are rations and the rationale and reasons, but again, this is going to have to be basically a separate case where you say, look, I'm actually innocent, overturn my conviction, and go from there. So really, once sentence is imposed, it is nearly impossible to withdraw your plea, right? You can't. And it's also very hard to get it set aside unless there was evidence that even if you find evidence that you're not guilty, but you could have found it before you pled guilty, but you just didn't, that's not good enough. It has to be like, oh, they invented DNA, right? Like DNA comes out in the 1990s. That changes things. Well, that changes people. Like, well, we couldn't have done a DNA test at the time because we didn't have DNA. We didn't understand it. Now we do. That type of thing is what's going to let you set something aside on a collateral attack, to set aside a plea agreement or a guilty plea. So that's that take on guilty pleas. That's the kind of the take on pretrial proceedings. There's a quick question that gets asked a lot is like, what happens if the prosecution doesn't do what they say they're going to do? What happens if the defendant doesn't say what they're going to do? So this is actually, plea agreements are just a form of contract, right, between the state and the defendant. Now, both parties, and usually we're talking the prosecutor, are generally expected to honor every provision of a plea agreement. And plea agreements are written out. They're written contracts. As such, if a defendant can establish by a preponderance of the evidence, so if they can establish by 50.01%, 50% and a feather, or 51%, however you want to conceptualize it, right? Just barely, it's more likely than not, just barely more likely than not, that the prosecutor violated the plea agreement, the contract, the defendant is entitled to one of two remedies depending on the circumstances. One, they may withdraw the plea, right? So if plea agreement is, okay, we'll drop all these charges, and at trial or at sentencing, we will make a recommendation of probation. And so you plead guilty, and then you go to sentencing. All right, and at sentencing, yes, they dropped all the other charges like they said they were going to, but when the prosecution gets up, he says, the prosecution recommends that this person spend 15 years in prison, and the agreement says that they would get up and recommend probation. At that point, you have one of two options. You can either withdraw your plea because they have fundamentally violated the contract to the point that it is just no longer enforceable. So you can withdraw your plea completely and say, nope, that's not what they said they were going to do. I withdraw. And again, that's a fair and just reason. The sentence hasn't been imposed. That's fine. Or they may be entitled to specific performance. And what this basically means is the court forces the prosecution to obey the terms of the plea agreement. Right? So this is going to happen more often than withdrawing the plea, but yeah, we're going to force you to do what you said in the plea agreement. So if you've agreed to reduce the charge from first-degree murder to second-degree murder and you don't do it, generally speaking, we're going to force you to do it, right? Because we have it written down. You file it with a court, and then you don't do it, we're going to force you to, right? So again, plea bargaining, the court is going to be very, very forceful when it comes to the prosecution. So that being said, the next class, we are going to begin the lengthy but very interesting and fun process of and rare process of the criminal trial. As always, if you have any questions, comments, or concerns, please do not hesitate to contact me. I look forward to our next lecture together.